Hello, Prophet Ron Dwayne Whitfield, recording live on Sunday, October 7th of 2018. This is first a response to the First Court of Appeals of Texas and two cause numbers, or rather docket numbers in that court, First Court of Appeals of Texas. The docket numbers are as follows. Three docket numbers. 01-92 00617 CR criminal case Whitfield versus State of Texas. Second cause number is docket number is 01-17-006 or rather 369-CV, an original proceeding for writ of mandamus. So actually they're going to be four. Again, let me start off so there'll be no chance of misunderstanding. I'm going to name these docket numbers. The first docket number is 01-92-00617-CR. That's a criminal case, Whitfield versus State. The second is a mandamus case, 01-17-369-CV, civil. The third is 01-18-00311-CV, notice of appeal case. And the last is 01-18-00485-CV. And that is Henry KLW, my child's initials. And I've received this in the mail, letter stating that I have a right to file a response to a frivolous Anders brief filed on behalf of a attorney for herself, stating that she has received the record, reviewed the record, and that there are no non-frivolous issues that can be presented for review in the Court of Appeals. This attorney then therefore has committed a crime. And, we're gonna go, my wife and I, to the FBI. Or rather, I'm gonna go to the FBI and do a food and water strike if I have to get this attorney, Justice Higley of the First Court of Appeals, indicted. Corruption, we're gonna get vigorous, as Judge T of the Court of Criminal Appeals would put it, vigorous. Corruption must stop right now. We're not gonna sit up. No. That shit got to stop right now. Not next week. People, we go forward. Calm down. We cannot just go. We will not go forward. This has to be. It's just like, for example, I like the way the first a Court of Appeals. I think it was a California Court of Appeals. So that would be the Ninth Court of Appeals. And I think the justice's name is Posner. And a lot of courts like to quote him in stating and arguing what is called deliberate indifference. And if I pronounce his name right, and if I got the court right, he pointed out that prison officials are liable if they know that there be a cobra in a prisoner's cell, or even the possibility that there's a cobra in a prisoner's cell, and they do nothing about it. And they put the prisoner in there, male or female prisoner, in the cell, knowing that there's a cobra now, knowing that there is a possibility that a cobra may be there. When I say cobra, I'm talking like a snake or a prisoner, violent, that's going out murdering, killing, that he or she murders or kill people. And they do nothing. That's deliberate indifference. So when we have corruption in the United States and we do not live, just like 9/11, that's something that we have to stop right now. We have to stop everything we're doing and deal with that threat. Corruption is a threat. So today I am saying that we must stop what we're doing, everything we're doing. If we're on the phone, if we're in church, whatever we're doing, and we got to stop corruption right now, not tomorrow, not see what the next president or anyone else is going to do, we're gonna stop it right now. So I'm moving with now I'm talking to the State Commission on Judicial Conduct, the Supreme Court of Texas, the United States Attorney for the Southern District of Texas, Houston Division, whose name is Ryan Patrick, who took the place of the former United States Attorney that the President of the United States, Mr. Donald Trump, fired. I'm talking to the United States Attorney General, Jeff Sessions, and I'm talking to the Director of the Federal Bureau of Investigation. The corruption right here in Texas, they have in Texas, CPS throughout the country, a criminal enterprise. That's what CPS is in the state of Texas. If they did not want me talking this way, if you did not want me to expose this, then you would not have presented, you would not have allowed me to be into your business. You would not, if you did not want this, so you wanted this, but you are content and satisfied that I won't be allowed to do anything about it. That this is $1 billion industry, criminal prize, and that before you'll let anything stop it, you would kill me. You will not kill me. You will not get away with this. You will not do it. So with that in mind, let me make my response. On Thursday, no, Friday. So if today is the 7th of October, 2018, then that was 2 days ago, Friday. I talked to who purported to be a friend of mine. And trust me, God would have me to befriend, or rather, he befriend me. His name is Mark Webster. He is the second in command in Houston of the Federal Bureau of Investigation, FBI. The second in command. The first in command is Special Agent in Charge, Perry K. Turner. And under him, he's the Special Agent in Charge appointed by you, Mr. Well, not you, but the other director. I don't know who appointed him. Could have been Mr. James Comey, Mr. Robert Mueller appointed Mr. K. Turner. I don't know who appointed him, but he is the special agent in charge for Houston. I don't know who's in charge for Dallas, San Antonio. I'm talking about Houston. And under Mr. K. Turner is like 5 assistant special agent in charge. And they run that. All the agents and the FBI police and the FBI special agents, I guess when these men come, they all run, scattered, whatever they was doing wrong. When they see them walking around, everybody are doing their job and, doing what they're supposed to. Everybody's complying with policy, acting civilized or whatever. I don't know. I'm not inside that, but I know how it was in prison. When you see an assistant warden coming, or the warden himself, or a major, regardless what the officers beating up prisoners or sex going on in the closet, whatever going on, but when the warden, major, captain, lieutenant come, all that ceases. I called who purported to be Mark Webster on the phone, and I'm gonna put that on YouTube, convert it into a video, so you can hear what I was told. Now, to me, I don't think that was him. So I'm going to call him and tell him that, hey, let me come. I'll be up there before I do a food and water strike. He knows that I'm going to, whoever this, if I was talking to Mark Webster on Friday, he's been informed that my wife and I, we will do a food and water strike. But today, the food and water strike is going to be unnecessary as it relates to CPS. Let me just jump right in. CPS. My response to the First Court of Appeals is as follows. I move right now. I'll bring this in as a video and on paper, let you know that this is my response. For now, I will amend this response later. But for right now, my response is that, 1, my rights to my child, KLW, not supposed to state his name, was not terminated for a number of reasons. The main reason right now that I'm going to give you, so I can come get my child, I'm moving in my response. I'm also motioning that you order my child, the judge, if he's been adopted, I don't know, that he be given back to me immediately. Now, where I'm finna need your help, because they don't want to do this. Here's why my rights have not been terminated. Judge Phillips' exact words from the bench, orders typed down, and in this so-called void judgment or the final decree is that not my rights were terminated. He terminated the rights of the alleged father. The alleged father. Texas law defines what and who an alleged father is. Well, please understand what I'm saying, because the United States Attorney and FBI have no choice than to go get my child, or they have to give me my child. I am, as the prosecutor, Rachel Johnson, told Judge Phillips, and he went off on her. And I'm finna send all that, bring all this to the United States Attorney on tomorrow, and the FBI, as soon as I get them on the phone, let them know here it is. And I'm telling you, the first court appeal, in the record of the final hearing, Judge Phillips terminated the rights of the alleged father. I am the presumed father. Texas law, not any witness determines the rights of the parents. They define who parents are. They define who an alleged father is. The laws define who a legal father is, or the presumed father is. Because and when the prosecutor, in this case, her name is Rachel Johnson, when she introduced into evidence, and the trial judge, John Phillips, admitted into evidence on April 12 of 2018, the marriage license of Ronald Dwayne Whitfield and Brandy Brene Charles, establishing, some say proving, that we were legally married on June 6 of 2016. She just proved that I was the legal father of Caden, of my child, KLW. She just proved that. And during, at the time that she rested and everyone else rested, and they presented their legal arguments to terminate the rights of the father, they requested, well, actually, she asked the judge to adjudicate, which he cannot do that, because before you can adjudicate the rights of the presumed father must be served with notice that he has been sued. And he gets to go through the same process as any other father. Due to him. And he, the presumed father, has not gone through this process. He has no notice. I am the presumed father. She, Rachel Johnson, requested military heading heading eastbound. What's over that way? Okay, still recording 13 minutes. So he, again, during the argument made by the prosecutor, she, first of all, again, let me just make sure I get all this in, not leave anything out. She introduced into evidence right off the bat. Who ever heard of people doing that and won't let you object to anything too? Off the bat, without establishing a predicate for doing so, to see that they are admissible without giving me an opportunity to review these documents. Thank you, though. She introduced into evidence, and they say, according to them, he admitted, Judge Phillips, into evidence our marriage license that established that, or proved that we were married lawfully by the probate judge of probate court number 3 or 4. Do I have a marriage license here? Into evidence that we were married 79 days before KLW, our child, was born. In so doing, she just established my status as the presumed father. The presumed father has not been served with citation and a copy of the petition. The presumed father has not been told that he has been sued. He has not been given an opportunity to appear and to challenge and dispute and defend his rights. Now, during what they call, or we call, closing arguments, not closing arguments, after the prosecution rested its case, then they moved the prosecution, the attorneys that, and these people that they appointed as child, I don't know, I can't call what they are, but they people from the same hospital that let me just keep this simple. So after the prosecution rested and closed, and then went on to present their legal arguments for the reasons why the judge should grant their requests to terminate the legal rights of the parties. In this case, they sued, or purported to sue, the alleged father and my child's natural mother, who is Brandy Charles, my wife. The prosecutor specifically asked the judge to go on and not terminate the rights of the alleged father, because our marriage certificate established that Ronald Dwayne Whitfield is the presumed father. He was married to his wife, to Brandy, 79 days before he went off. Judge Phillips went off on her. It was like, I don't want to use profanity here. The hell are you talking about? Why are you doing this? Well, Judge, they were married. I don't care. Why are you doing this? You doing this on the record? You catching me by surprise? I don't know what to say. You pissing me off. Why are you doing this? Read the record. Well, Your Honor, they were married. I don't care. Why are you doing it? Well, okay, Your Honor, I'll rephrase that. And I'm not asking you to do it. I just want to know why you're doing it. Okay, yeah, I get it. Well, and she went on. And so they terminated the rights. This is my response. Judge Phillips terminated the rights of the alleged father, who even the alleged father was not served. And we have two attorneys, one named John Miller and the other one named Valeria Brock, who is a sham attorney. She was purportedly appointed by Judge Phillips. Judge Phillips had no authority to appoint her because the court itself had no jurisdiction or power to appoint this attorney to represent my rights. And I'll talk about that later. United States Attorney Attorney General Jeff Sessions. My mom's rent man needs to he'll be pulling up to pay me for mowing his lawns, property. I've made it very clear. The proof in this case, which imposed a duty, because you did take an oath to protect and defend the Constitution and the laws of the United States, and the Constitution of the United States is that no person can be deprived of life, liberty, or property, and that's the United States Supreme Court's opinion have stepped in and added that, or recognized that the Constitution also protect the liberty interests of parents, that they have fundamental liberty interests and fundamental rights to the care, custody, and management for the upbringing of their child. So when a judge under Title 18 United States Code Section 242, whosoever, doesn't matter if you are employed by CPS or it's the state of Texas, which is a sovereignty government, or whoever, a state judge or any employee of the state and any agency acting on the color of law, any law, policy, custom, usage, willfully subjects any person in the state of Texas or any other state, the district, anywhere subject to the United States, the jurisdiction of the United States, to the deprivation of any right not given by the federal Constitution or laws of the United States, not given by it or them, the Constitution Constitution itself or the laws of the United States, but protected by it or secured by it, commits an offense. So I have to identify what right that it secured or protected that State Judge John Phillips and CPS and county attorneys and Memorial Hermann Hospital, which is a corporation in the state of Texas doing business as Children's Memorial Hermann Hospital in the Texas Medical Center. These attorneys, if they are acting under color of any law, and they have to register with our Secretary of State in order to do business in the state of Texas. So once we determine that they are acting on, and then the Federal Bureau of Investigation on its website expressly acknowledges that they are. So there's no question about who is or who was acting under color of the laws of Texas. So once I identify what rights have been willfully denied without due process of law, then I need to present sufficient facts, something known to have occurred to establish that that has been done. Then the Federal Bureau of Investigation, without regard to whether or not the facts constitute an offense under this section, the Federal Bureau of Investigation and the United States Attorney General, Mr. Jeff Sessions, the president of the, President Donald Trump can issue an executive order, Mr. Mark Webster, my good, this is you who I was talking to, and the man order the Attorney General to order the director of the FBI to order a real investigation. You, the Federal Bureau of Investigation, you do not determine whether or not these allegations constitute a crime. That's not your duty. That's not your purpose. That's not the creation of your office to determine whether or not these factual allegations constitute a crime. Your duty is just to investigate. And then the law requires that you, how you doing? Require that you present these at the conclusion, just like United States Attorney, Assistant Attorney, Chief Deputy Attorney Andrew Bob stated to me on the civil side of it. This is what you do. You, and I'll come back so I can show people I know how to keep a chain of thought, even though I get distracted when this is just as important. You can file a complaint with the United States Department of Human Health and Services. They will, not might, may, will conduct an investigation to your allegation, and they will get it, the conclusion, their findings to my decision. I get to decide whether or not United States, they don't get to decide, they just the investigators, whether or not I would bring civil charges against a complaint against Texas Memorial Hermann Hospital and Texas Medical Center. That's up to me. Now, just as he has already, and I got him recorded stating that, it is not the director or either, and nor even you, Mr. Mark Webster, my good friend, but I don't think this is you I was talking to, because you and I have already had this discussion before when the other United States Attorney General, United States Attorney was there, and I got a whole story about him. Had to call the police on him, and because he had committed a crime against me. Thank you, Mr. Trump, for firing him. When he was also the Harris County District Attorney, he did a bad act against me. That's why he didn't want me up in the United States Attorney's office. He's no longer there. Now, Mr. Ryan Patrick gets to decide whether or not he will take this case to a grand jury, whether or not these allegations constitute crime. Not the FBI, they don't get to do that. So whoever I was on the phone with, this, to the extent that they are telling me all this bull crap, and I in the name claiming that this is Mr. the second in command at the FBI, I will call him on tomorrow. I'll come in or you will come out and let me see your face. And if that's you saying it, then I'm gonna prove you. Let's see if I can pause this. I'm gonna have to pick this up, go. He wants to pay me, so let me not hold him up. It's my mother's rent man. Wants to pay me for my work, so let me deal with him and pick this back up. But let me do it quickly. This may be him over here parked, and if so, yeah, this is him. I didn't recognize. How you doing, sir? I didn't recognize. I see you in another vehicle.
Look, you cut the grass?
Yeah, mom told me late in the afternoon. Well, I left you a voicemail that I can't. It's yet to learn to pronounce your name correctly. So when she told me around, I didn't got started. I've done this and done that. So I lagged just to go ahead and weed eat and that other house around the corner.
Okay, that's what was it, 95?
Let's do the math. As I told you before, because 25, 30 for that one. So 25, 50, 30. You got a break.
30,
75 and 30. Yes, sir.
25?
Yeah, if that's the math, yes. Because math, we don't never went to war with a math problem. Yeah. That's what that comes to, yeah. 4, that's what that comes to. And if I can take pictures, I post. Sometimes I be so busy, but I try to, that trust, because I was, raised by a brilliant judge. He responsible for a lot of people going to Congress, like such as Barbara come over to the house when I was like 7 years old. Mickey Leland, Anthony Hall, Craig Washington. Wrong, that's Biden. He was their mentor. His name was A.E. Jordan. Did you know Jordan? He was the judge. He was the precinct judge out here. We used to open the polls and count the votes and call them in at night on election night. He used to have me out there vote for Anthony Hall or vote for.
Okay, it's 105.
Okay.
I don't have a book, but the next time we'll get inside.
Okay, yeah. Keep a good record of transaction. Okay, I know that's right, miss. All right, then. I'll call me and I'll remind me to send you some pictures. All right, thank you, sir. Of the property being mowed, complete, the job completed. But I want to hurry up and get this video out there. I was just explaining to him how Barbara Jordan, late Congresswoman Barbara Jordan, Mickey Leland, who was killed in 1989. Houston Marvin Zimmerman went over there. He was heading to Africa. I was in jail at the time. He, Craig Washington, Anthony Hall, a lot of my godfather would call. He was born in 1900 from Dallas, Texas, made home here in Houston, Texas. He was our precinct judge over 30 years unopposed. He argued to me that Pearlie Cooper was put up to run against him after over 30 years unopposed because he was causing the city of Houston too much problems. And she worked for the city. He would explain to me that Pearlie Cooper cannot do any good for our community and work for the city of Houston. City Hall gave me the devil in getting Fire Station 46 built. When in the 60s, when your house would catch a fire, by the time the closest fire station to us, Ronald, was in Sunnyside. And by the time the fire department got here, your house was burnt up. So we needed a fire station in our community, and the city of Houston would give me the devil. We needed sewer system put in. We needed sidewalks. And I fought like hell. And I was there with him, but I just wasn't knowing what he was doing at age 7. But I was always there with him. And when Barbara Jordan would come over to the house and Craig and Anthony Hall, he would tell me who these people were. But I was, I'm 7 years old. But they, at least how you doing, ma'am? And, I'm respectful. He was their mentor. So this man raised me to not be a doggone fool. And they want to say that I have a mental problem because I get aggressive because I'm recalling the knowledge that he taught me as a child. He was a radio and TV repairman. He was a pharmacist. He was an electrician. He was an inventor. He invented a lot of things and wouldn't put a patent on it. He was a school teacher for over and college teacher at the same time, contemporaneously with Jack Yates and Prairie View University College. And he never missed one day. And that's because Ronald Miss Jordan, his wife, not the one that ran, she just his mentor. She would come over there and learn from him. Made me stay at home upstairs in the bed. So therefore, had she not made him, his wife, stay at home in the bed, he'd have went to work sick and would not have missed not one day from both schools. I mean, education. High school, Jack Yates and Prairie View would have out of 30 years, never late. Ronald be dependable. Oh, he taught me a lot. And and then they hate me for being who I am. Hate me for being who I am and want to try to say I got no issue. I have no issue. It's just that I was raised, the women in my family, I'll get back to where we were. They taught us, don't be a damn fool all your life. I was taught things such that don't have your lit friends in my house tearing up my furniture. You go to their mama's house, and if their mama let you come in there and tear up her furniture, that's her. But I don't want these in my house when I'm not at home, and even when I am here. Y'all play outside. But moving on. Judge Phillips ruled that his ruling was not rendered in writing. His ruling was announced in open court from the bench. So that means what is entered into this, what we call formal judgment, is to reflect what took place in open court. Now, a judge can render in Texas judgment in one of two ways, either by written memorandum or by oral. I was making a lot of noise, and I want to make sure the audio is good. He rendered judgment orally, and his judgment was that I will grant your request. Well, our Texas Supreme Court has stated that that judgment is void, and the reason that is that not because I'm gonna use correct. I use now correct English grammar, demonstrating that they're not dealing with a damn fool, a doggone fool. He rendered judgment orally, and his judgment is void because he said I will grant your request instead of saying your request is granted. He did not render judgment at the time. The judgment rendered must be a present act, a judicial act. It must be in the present, not in the future. And so this is once our Supreme Court has declared what the law is, it's the law. Therefore, because and the record proves that he did not render judgment on April 12th of 2018 at the bench, sitting on the bench, what you see filed with the clerk as a record of the court of the action taken by Judge Phillips is void. They cannot, that's my response. The judgment is void. So there'll be no chance of you all getting away with this corruption. The judgment is void. I use the word ruling, which means decision. Now back to the alleged father. Even as judges say, assuming arguendo that the judge had rendered from the bench a valid judgment, the legal result is the same as applied to Brandy and to myself here for the following reason. Again, rather than suing to terminate the parental rights, ooh, look at all my papers, of the presumed father, and there's only people determines who presumed father is. The law, not a witness, as Judge Phillips would have you believe. It's changes I go through. But as Frederick Douglass said, those who profess to favor freedom and yet deprecate, no, he started out by saying that the whole history of progress of human liberty shows that all concessions yet made to her august claims have been born in earnest struggle. The conflict has been exciting, agitating, all absorbing, and for the time putting all other tumults to silence. It must do this, or else it does nothing at all. Those who profess to favor freedom and yet deprecate agitation, as I'm being subject to agitation, are men and women who want the crops without plying up the ground. They want the rain without the thunder and lightning. They want the ocean without the awful roar of its many waters. So I understand that I have to go through some things in life. You know, I understand that there's going to be agitation. I understand that. So I have to, accept that. Now, return to what I was saying. I'm making it clear. I've done it 3 or 4 times already, that when the prosecutor, after she rests, her name is Rachel Johnson, there's a record. First Court of Appeals 3708 has the record. I will get this all over to my family. Hey, y'all hold this here. Here's the record. And they will understand that the prosecutor argued that the judge she argued that the judge, but this would have been still an invalid ruling, nevertheless, that he terminate the rights of the presumed father, because she argued the record reflected that my wife, Brandon, and I were married approximately 79 days before our child was born. Texas law determines who the child's father is, or any child. I prefer to say my child's father is. Texas law, not a witness, but Texas law. Texas law provides the first subdivision 1 of subsection A of Texas Family Code section 160.204. So again, this is Texas law, which determines my status, who I am. Says that under Texas Family Code section 160.204 subsection A subdivision 1, that a man who is married to the child's mother before the child was conceived is the presumed father, is the legal father. He has rights. Not no alleged father, man, walk around telling the world that's my child. Yeah, it might be, but as a matter of law, we don't know he's not. As a matter of law, he may be your biological child. You walking around with your hat on backwards, britches falling off your behind, claiming that's your child. That's not proof. Even if DNA were to establish that you be the legal father, then still the law is like, what that mean? You the legal father, but you do nothing for this child. You do not live with, you don't do anything. So your rights will still, that doesn't mean DNA prove that. What that mean? You doing nothing for the child. You have to have legal rights, but that's a whole different area of the law. The law is this. She moved that the alleged father's parental rights, and alleged father is not considered a parent. He's not. Now, the alleged father, he has rights, such as the right to be informed that that the parental rights of the child is being terminated, and that he may, if he registers with the vital statistics units of the Texas Department of whatever it's called, I'm not thinking right clearly on what it's called, but it's called the Vital Statistics Unit. An attorney that represents the interests of an alleged father, that's all that attorney will do is locate him and make sure that the department has made sure whether or not he has or has not registered. But as far as the presumed father, they did not sue him. That's the law determines who I am, not Judge Phillips, not any witness, whoever, anyone else, the law. Because the law declares that I am my child's biological and legal father. That's who has to be sued, the presumed father. Because Judge Phillips, terminated not the terminated the parental rights of the presumed father, but of the alleged father. And since I'm not the alleged father, I want my child. I took all day to make that clear. I had to do it that. I felt to do it that way. I want my child. I, again, am the presumed father. Now, again, this is in what they call evidence, the proof, the marriage license between Brandy Brene Charles, and her name is not changed to Whitfield because we just haven't gone. We did go over there, but they told us at the time to bring the marriage license, and her name would be then changed on, it's done through Social Security to Whitfield. But until then, her name will remain Charles until we bring, and we just haven't been over there. I ain't feel like going all over there yet. So that's why her last name is still Charles. Now, again, I don't know how to keep saying it. So in case they try to lock me up or kill me or whatever, that's what I keep telling them. This Justice Higley, she can't deny. This is what the record reflects. This is what the Supreme Court of Texas has held. This is the law. I am the presumed father. And before due process, before I can be terminated, I have to, one, be served with a citation and a copy of the petition and afforded an opportunity to respond by filing what is called an answer and an opportunity to appear in opposition. And I get 20 days in which to do so and to hire an attorney or represent the matter or defend the matter myself. Texas law, Judge Phillips has admitted in an order that a party has the right, he knows the law, he's a judge and also an attorney, has the right under Texas Rules of Civil Procedure, rule number 7, to a party to either defend and represent a lawsuit by him or herself or by counsel. Because I was not served and sued, I was not sued. He has not terminated my right. Therefore, FBI, therefore, United States Attorney, therefore, First Court of Appeals of Texas. This is my response and a motion that you take appropriate action. There's no chance of you not getting it. That my child, KLW, that CPS has custody of, be given back to me. Given back to me. The presumed father. I was not sued. They admit I was not sued. They admit that I was the child. My child I was married to his mother. Now they know who I am. And the judge, she argued. Rachel Johnson argued to the judge. Judge, you're gonna make a mistake here. Judge, she tried to tell him. Judge, he is the presumed father. He went off on her. Why are you doing that? So, okay, Judge. To the extent, and she went on. We asked that you terminate the rights of the alleged father. And he granted her request. Because the record proves that I am the presumed father, not the alleged. I demand my child right now. I demand that my child be given back, not tomorrow, not next month, but right now. Once you are legally put on notice in this response, I move that you order. Right now, render an order to either CPS, to the trial judge, to return my child to me, right now. Now, the next issue is that as for my wife Brandy, Brandy has put in the record. We went over to MHMR. We got her. I don't like people all in my business like this here just right now, but we went to the MHMR. We obtained from Dr. Williamson, who instructed Nurse Joyce to have Brandy to have the FBI call and to have Brandy's case manager to have Brandy execute a not waiver, but a authorization for the release of Brandy's drug lab records, which CPS had already obtained and took out. CPS has gotten an order from Judge Phillips to obtain Brandy's MHMR records. And MHMR has given those to CPS, and CPS took out the drug records that reflected Brandy has not tested positive for any unlawful drugs since 2015. Brandy and I learned that we were pregnant in January of 2016. And when we learned, Brandy and I had an agreement that no more weed. That's all she ever used was weed. From this day on, learning that she was pregnant, Brandy's not used any weed since. She did after Caden was born. She told me she went outside one day. She was stressing and she hit tried to hit a weed cigarette, and it was so strong she got couldn't even inhale it after having been not smoking so long. So she never even got it down because it was so strong for her. And she went and gave it back to the people she had bought it from. I can't, this is too strong. And has not, so therefore she's not, that's why I keep saying she tried to hit it, smoke one time, but have not smoked in all that time. In over a year, 16, Brandy had not smoked since January of 2016. So now January 2017 is 1 year, and you go all the way to March. And now here she is going to someday I know why she was stressed, because I had went off on her about Brandy knows how to, and Brandy invented a fan and wanted to put it on the market. Had USB lights and all kind of gadgets. And she gave this company, a corporation, $500 just to get started and getting the thing on the market. They'll say, and I told her not to do it because one, it could be a scam. Two, our bills first come first. We'll get to that someday in the future. She went against my counsel and paid them people $500 anyway, as if the not rent, but the light bill gonna get itself paid. And I'm out here working like a dog trying to make ends meet. And then she did that, and I was unhappy about that. And I was letting her know, now that you done this, how this light bill gonna get paid? So now she's stressed. She see her mistake. So she went without my knowledge and bought a $5 bag of weed or a $10 bag. I don't know what the hell it was, but this is what she told me. She said, I tried to smoke it and I couldn't get it down. And she went and took it back. And then here we got a CPS man coming at my door, lying to us. She tested positive for drug. How? That's impossible. Thank God, MHMR been testing her. Dr. Williamson, Mark Williamson at MHMR had been testing too. He has a duty to test her. He's a doctor. And because if something happened to our baby, or he was not testing her and she's pregnant and our baby come out deformed or whatever, then he's liable. MHMR is liable. So he had to test her. We didn't know he was testing us. But getting back to the point, CPS took out these records. That's what we call fraud upon the court. Rachel Johnson, the prosecutor, and CPS removed these records and put into evidence just the other portion of that she was on the MHMR. But in so doing, not only did they put into evidence that Dr. Williamson has a document in there stating that Brandon has given him at least 10 reasons why, although she does hear voices that you and I are not hearing, I'm sure, and that these voices have instructed her to do harm to herself, that Brandon's told, listen, 10 reasons or more why she would never do it, why she has a reason to live. Yet CPS is arguing that Brandon is not consistently treating her mental illness. How can CPS make such an argument when, I'm asking, of course, how? So I guess I'm asking you the question, how? Can the prosecutor says she's not consistently treating her mental health illness when has been under the care of a doctor since 2015? How are you going to make that argument? Are you saying that Dr. Williamson does not know what he's doing? Because every time he tells her she has an appointment, she's there. Every time he orders her to take these urine analysis tests, she takes them. She's making all the appointments. So there's no basis for that argument that she's not consistently. But this is what they get away with when you don't have an attorney that's representing you. 51 minutes. But now that's fraud upon the court. We have Brandon in her motion for all her pleas in the first court appeal since this attorney has been forced upon her, has filed his frivolous amicus brief, has shown the court why she was able to do so, what they call pro se, in her response, that's been fraud upon the court. Because these records, so that's a new trial right there. Alone. That a new trial. I think I'm not sure that can even be a new trial after fraud on the court has been established. I'll research that further. But you do know that the judgment becomes void because CPS and the attorney, Harris County attorney, cannot put and then alter. They had Brandon going to drug places during the entire time of this case. And every time that they're putting in the system, what they're doing is they take out the negative that these drug companies have shown that and cut it out or white it out. If you cut it out, just take a razor blade, cut out the word negative in a square, take that little piece of paper out saying negative, get a white sheet of paper and put behind that and make a copy of that page. And then when you do so, you're altering. That's a crime on the Texas Penal Code, chapter, I forgot what it is, 37 or 39. You alter a governmental record. Well, I don't know if that's considered would be a governmental record, but it's still fraud upon the court. So they altered the original record that they received, a copy of the original that they received, CPS received from the lab drug report, changed the word negative and put it over far to the right. Everything is lined down negative, 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 negative. So where it says positive for cocaine, they cut that out or either whited it out and made another copy of that showing that it's blank, making it be blank. And over here, instead of putting positive underneath where it says negative, they so silly, they put positive way over to the right, making it stand out by itself. I guess, why is it way over here? Why is it not showing, if you were positive, why is it not lined up, consistent? Because they altered that and then put it into the system and been telling Brandon she's been testing positive for drugs. You've been testing positive for drugs. Oh, who said? I know I have. Yes, you have. The drug company said they lied. No one came into court and said that I am the custodian of these records and these are true and authentic copies of the original made at the time and whatever, that yes, this, and compare them with what the drug company has with what they are trying to seek and introduce at trial right now. And someone that not only just the custodian of the record must come to court and say that these are true and authentic copies as they appear on file in my office. I have compared them, but also even the person who put the negative in there must come to court if it were truly positive and say, "Nah, well, I tested her. I tested these whatever they refer to them, the specimens or whatever, and how would I know? I test them every day. I can't say whether they were positive, but you would have someone to come in to testify to the authenticity or validity of these reports. That did not occur. Therefore, that's not admissible. It's not admissible to any evidence. And to have no attorney to challenge that would be a crime, as well as ineffective assistance of counsel as well as no counsel at all. You just allowing the state to present without testing, challenging anything. How we know that you didn't alter this? How we know? Let's test this. People, we live in the last day. People do evil, and that's what they've been doing. Evil. That's why I say it's gonna stop. We're gonna stop that. Not in the United States. That's got to stop right now. That's got to stop right now. Now this should be enough. I've already get my child back, but for as the rights are concerned, I've already established that Judge Phillips did not render a valid judgment. That's under attack. That's my response. It's under attack. Another reason is that, assuming that Judge Phillips had rendered a valid judgment, let's talk about the facts. Judge Phillips, this is what happened, people. As far as the conditions of the law that authorizes conditions. You notice I used the word condition. Under Texas Family Code section 161.001 sub paragraph B sub part 1 sub paragraph E. I have to break that down in my mind to use the correct terminology. So I'll do it this way too. Texas Family Code section 161.001 E provides that gives a trial judge authority acting for the court to terminate the parental rights of the mother or the father. It uses the word parent if by clear and convincing evidence, and evidence is something known as facts. The evidence show that the parents, this condition is that the parents engage in conduct that placed our son in danger, or we put our child in the custody of someone else who caused our child to be placed in danger of our child's health, safety. I don't have the law, but it's talking about it's a condition that if the trial judge find find by use the preposition by clear and convincing evidence that we engaged in behavior, misconduct that cause our child to be placed in danger, physical, some kind of danger to his health and safety, then the trial judge, if he finds this by clear and convincing evidence, then he may terminate our parental rights. The argument that the prosecutor made to this finding that she needed him to make, he responded, I don't know what that had. She argued that because my wife is hanging around her husband, and because she is testing repeatedly positive for drugs, and because she is not consistently treating her mental illness, this shows that her parental rights should be terminated. And Judge Phillips, instead of saying I agree or agreeing, he stated his response was exact words, I don't know what that has to do with that law. E. But tell me about O. Because I don't know what that had, what the hell you talking about has to do with E. How can I can't make a finding of what you're arguing under E. But tell me about O, subsection O. He made no finding under E. You cannot make a finding that my wife, Brandy's parental rights should be terminated because the evidence shows that she has engaged in conduct that places our child safety or health in danger because she is still married to her husband, hanging around her husband, legal husband, and that she is not consistently treating her mental health illness Well, she goes to MHMR every time Dr. William orders her to be there and does everything he says do. And because what else? She's using drugs. Well, we know what the MHMR record shows she's not using, hadn't used drugs. And that's why Dr. Mark Williamson told Nurse Joyce to tell Brandy to have the FBI call us and have Brandy's caseworker to provide Brandy an authorization to execute so that they will be lawfully authorized to provide to the FBI all her medical records. Because now doing so, y'all implicating Dr. Williamson into a crime and his license at stake by the time he's letting her, use drugs and not reporting her. So you see how this works. You got doggone like you're not gonna have me involved in this stuff like this here. She's been tested negative. Had she been tested positive, I'd have reported her to try to have a duty to report her. See how that works? We supposed to be a doggone fool. So I just established that Judge Phillips made no finding under subsection E. Made no finding. Stating, I don't know what that has to do with that. Now he asked, but tell me about O. What are you saying about O? And under O, she's saying that Brandy failed to complete, use the word complete, her treatment plan under subsection O. Well, it's a problem with that. Here's the problem, First Court Appeals, and my response and Brandon's response, which is already in the record. Already in the record, because see, Justice Higley, they only talk about it, ignore that, but you can't ignore that. See, the law determines the relief. The law, not the justice. Just in applying the law to the fact, we don't have to worry about a judge rendering a bad decision or incorrect decision, because the law is the decision determined. In this case, here, his theories, legal theories, arguments. First of all, there was no evidence whatsoever in my response, and Brandon's response is already in file in this case, showing that in order for a judge to terminate a parent right under subsection O, the judge must find by clear and convincing evidence that the parent failed to comply with an order that specifically stated the actions that the parent must take in order to get the child returned due to the child being removed for the abuse or neglect of the child. That is key. What is key, y'all? For the abuse or neglect of the child under chapter 262 for the removal. They thought we were doggone fool. There's no evidence establishing why our child was removed. Under subsection O, it is not what occurred at the hospital, because our child was not removed at the hospital. The CPS, Judge Phillips, was not at the hospital. Well, they alleged the child abuse occurred. Rachel Johnson was not at the hospital. She's not a witness. Savannah Johnson is not. No one is a witness. Nobody in CPS, the judge, CPS, the attorney, nobody is a witness to that. There's no evidence, even with the testimony of the woman at the hospital. That's not why our child was removed. She did not testify that our child was removed at an hospital for abuse, physical abuse, or neglect. Our child was removed at his house. That is why it is called an affidavit of removal. The affidavit of removal does not say that our child was removed pursuant to Texas Family Code section 262.104 subsection A2. The conditions that the state, not the federal government, not the federal Constitution, Fourth Amendment, but the state of Texas. The state of Texas law cannot conflict with the Fourth Amendment. And the Fourth Amendment and the Fifth Circuit has stated that we don't know what the condition. Look, people, you're not dealing with a damn fool. 1 hour. Our child under subsection 4 was removed from his house under subsection. What am I talking about? Subsection 4. There is no evidence in the record to establish that our child was removed from his parents for failing to comply with an order that specifically stated the actions that we must have taken in the future in order to get our child back due to. Now I use the word as it is an adverb. It shows the work here. Damn it. Due to. Do I need to state English grammar, these parts of speeches, the work that they play? The removal of the child owing to the abuse or neglect. So in order for Judge Phillips to make a finding that we have failed to comply with a order with specific provisions that we must comply, with which we must comply, because you can't use a preposition at the end of a sentence, God doggone it, and use correct English grammar. You can't do that. So the child first has to be, it must be established that the child's removal, the removal of our baby was due to physical abuse. And not just that she failed to comply with an order, but that the removal was due to physical abuse. Now, you have the record first, Court of Appeals Justice. We're in that record, both at the so-called show cause hearing and at the final hearing. We're in that record. Nowhere in that record does it state that our child, there's no testimony, there's nothing in the record, absolutely nothing that says that, proves that or states that our child was removed from what they purportedly was that show at the adversary hearing or show cause hearing, and at the final hearing that my wife was at the hospital and stated that she, and which is not true, other than she hear voices, but not that the voices told her to kill herself. And still, even so, what that mean? What's she gonna act upon it? That's what you want. Was she gonna do it? Did she say want to do it? No. Okay, so there was no evidence to that. But thought they was dealing with a damn fool. Now, the record is this: no one came to court, no one, absolutely no one, and stated that my son was removed from his house due to the physical abuse or neglect. That's why he was removed. Therefore, under subsection O, there's no evidence of that. And as well, and equally important is this: you cannot use subsection O as a basis for terminating Brandy's parental rights when there is the testimony from the caseworker whose name is Savannah Johnson, who claims she is the caseworker. They're stating that I did not give Brandy this service plan. Why? Because it is the policy of CPS that she signs this service plan in the presence. It's me, Ray. That she signed. Hey, it's me.
Oh, go ahead, what you say?
I was just making a recording video.
Oh, okay, how you doing?
I'm good, and you?
I'm glad you put my interview. You would got it.
Oh yeah.
Right on.
Oh yeah. I cannot terminate Brandon's parental rights. That's what is that? What they call it? It's not a dilemma. Alligators or the crocodile. That's a dilemma. It's what they call a catch-22. All right. I'm recording right now. Can you hold on? Okay, I'm making a live video all over the world. Let me just finish this out.
Now for real?
Yeah.
Wait, what I'm trying to do, you got a suit this Saturday?
I have a soup. I can gladly get.
I come right back here. I got to go and check on the neighbor right there because they're not answering the phone. Okay, they is.
Well, please go check on them. Okay. Okay. So, Savannah Johnson, who was assigned to the case, later stated that she did not give Brandy the service plan to sign because it is the policy of CPS that the service plan be executed in the presence of her attorney. So the service plan was not given to Brandy and not signed by Brandy, nor by me, because according to CPS, Savannah, who's speaking for CPS, that they preferred that it be done in the presence of her attorney. But her attorney has been too busy beating up on computers at game rooms, thinking that this computer or machine is going to give her money. And that's been recorded, called her gambling, showing that so in other words, it never got executed. and it's got filed. Brandy never got the service plan. Instead, Brandy received a sheet of paper from Savannah Johnson telling her where she can go and do parenting classes without Brandy ever reading and understanding what the significance of the service plan was. Nor had Judge Phillips even inquired into, have you received a service plan? Do you understand it, which he has a duty to do? Do you agree to comply with the service plan? Yes, I do, Your Honor. I did get it, and I'm going to comply with it. Well, okay, then sign it, because if you do and comply with these programs, then you'll get your baby back. But only if you comply. She never got that. And again, that's what's in the record. So not only did she not get the service plan, not only did she not execute it by putting her name on it, which means I've read it and I agree to comply with these conditions. We have a contract here, it's binding. And if I fail to comply, then the judge, I cannot contest that because this is an agreement. She never got it. So therefore, he cannot use First Court of Appeals. Is what we've been arguing to you and what Brandon has argued to you, even where none of these other jurisdictional issues here present, that under subsection O, the order is void were there one lawful or valid because of this. She was not giving the service plan to sign, to read. Instead, Brandon got a sheet of paper telling me to take her here, take her there, and I took her everywhere she had it to go. I did not, and I got audios for myself where I told Savannah Johnson, her supervisor, Courtney Wilson, I have told them all. And we're going to have to go to the FBI and the United States Attorney so you can hear these, maybe 1,000 of them, where I'm telling them I was not served. Neither as a alleged father, nor as a presumed father. And they still telling me, I'm telling them the court has no jurisdiction over my person because I have to be served. And if I were to comply with these requests that you are making, then I would waive such jurisdictional effect. I cannot do any act that would be constituted a general appearance. When I was in jail and I received, they informed me that the Judge Phillips had and CPS, they conspired, but I can't prove all that. I can because I got a recording from CPS Savannah Johnson calling me, asking me for my parole officer's name. And after that, they kept arresting me, having me going to the crazy doctor. And the crazy doctor repeatedly kept telling them, and it's on YouTube, this man has no mental issues. I'll put on YouTube, excuse me. I'll put on YouTube the proof where the crazy doctors, the crazy health community, the crazy people, they have stated that don't send him here. He is not crazy. They told Texas when I was in the Texas prison system, I refer to it as hell, that I do not have mental issues. They informed, Texas knows that they once asked me, did I hear voices? I believe that I know that all people that are not deaf hear voices. They hear sounds. So for the crazy doctor in 2008 to come and ask me, do you hear voices? And when I responded, yes, I do. To me, something was wrong with the crazy doctor for even asking me such a question. I am not deaf. So of course I hear voices. I hear you asking me this question. But as a result of making this statement, they entered in their system diagnosing me as being paranoid and schizophrenia. Have I told a crazy judge, Social Security, when they was granting me my Social Security benefits, the truth about this? And the crazy judge, you tell me, yeah, man, I've read your records. You've had a rough ride in Houston. This is December 10, 2012, I believe. Or December 10, 2011, when I went to see the crazy judge. I get it, but I've read your records. And they record that. And you've had a rough ride. So basically, he's granting me benefits not because I'm paranoid or schizophrenic or crazy, but because the hell I went through in prison. He told me out of his own mouth, I read your records, man. And I'm letting him know, just like I let the crazy judge know, and the crazy judge the second time when I went back over there trying to get them to, because they messing over me, for lack of better words. And the crazy judge put on in the record that Mr. Whitfield says that he was working, but that's going into a whole nother area. Back to the facts of this case. The crazy judges, they know there's nothing mentally wrong with me. The mental health authorities, steady telling the state of Texas, there's nothing. This man has no mental issue. He is just the type of person. He's like militant. I'm like Malcolm X. I'm like Martin Luther King. I'm nonviolent, but I resist authority nonviolently, passively. Say for example, someone is doing a judge, a police officer, someone in authority is doing something unlawful, and I know it's unlawful. I will resist that, not in behaving violently, but in a way like Martin Luther King would do. He would violate, for example, no parking here in front of the FBI. I'll park there anyway. And then they'll tell, come on, put your head behind. I put my hands behind my back. I'm not going to strike them. No, I'm not doing that. And then they put me in jail and I'll stop eating. Protesting. That's the way I react. I am what we call spiritual. I believe in the Christian faith, not the Muslim faith, Buddha, or anything. I believe in believe. I don't like the word believe. Think. Feel. I operate on what I know. Damn what I think, feel, and believe. That could be misleading. Nah, I feel a toothache. That's okay, look. So back to the EO. The reason there's an affidavit of removal. I'm still making my response. As well as to the ground for why we're going to arrest these people, because you're going to have a problem. The problem is that you're going to have is that Brandon and I are not going to eat. And the world is going to understand why we're not eating. Now, you are the judges of the First Court of Appeals, the Texas Supreme Court. You cannot not give us our baby back, because this is the law. This was the law this was the law in effect on May 6th of 2017, and it is the law today. It was the law at the time that this happened, and it's still the law today. Now, again, the affidavit of removal states that my child was not removed under Texas Family Code, Section 262.104, subsection A, subdivision 2, based upon information received by someone else. Well, how does it go on? And taken together would show to a person of caution and reasonable prudence that there, at the time that my child was removed, was no time to obtain a warrant order, but that my child was in imminent danger to his health and safety. There's no order. There's no evidence, or what y'all call evidence, I call proof. There's no proof saying that he was removed based upon him being in immediate danger. That was some kind of, he was threatened by me. Threatened with imminent danger. That's the only way you can remove a child. My child has to be, there was no evidence that at the time, notice how Hillary Clinton always kept saying at the time, and former FBI Director James Coleman kept saying at the time. Texas law provides that at the time. No, at any other time. But there has been no proof that at the time my child was removed, he was threatened with imminent danger to his physical health or safety, because there was no proof that he was threatened by me or anyone else with imminent danger to his physical health. Then subsection A is invalid. Is invalid. Is there a better word to use? Not valid. It's misplaced. Any reliance by Judge Philip upon subsection, because there's no proof, there's no evidence. Not that that the evidence is insufficient, legal or factually insufficient, that for purpose of subsection O, which is the ground that he purports to terminate both Brandon and myself under that at the time, and we failed to comply with an order. Okay, so I've made that clear. What the affidavit of removal states is that, and the Fifth Circuit people, go read it. The case is called Gates versus Texas Department of Protective and Regulatory Services, comma, 537, capital F, period 3, small or lowercase d, page 404, parenthesis, 5th TH, circuit, capital C, small I, lowercase r, period, 2008. This means that in volume 537, Federal Reporter, 3rd edition, appearing at page 404, was a decision, or call it ruling, reflected in what is called an opinion. And there is a separate judgment that is not reported therewith. And in this opinion, handed down or filed, the opinion could have been made 3 days earlier, done, all polished, but it was filed with the clerk and became a record of the court and ordered published for the world to see on July 8th of 2008, telling Texas, Alabama, Georgia, Louisiana, and maybe one more state that the United States Court of Appeals for the Fifth Circuit has territorial jurisdiction over which it has jurisdiction, that from this day on, if you be sued for going into someone's house without a court order, consent, or exigent circumstances for billions of dollars, you're on your own. You have no qualified immunity. You explaining to Texas, the governor, the legislature, the court, we pronounce the supreme law of the land. You, under our supremacy clause, Article 3, Section 6, providing for the, I'm just going off the top of my head. The supremacy clause states that this federal constitution is the supreme law of the land. I don't know about the sea, but it is the supreme law of the land, and anything in this constitution, laws or treaties, it's the supreme law of the land, and anything in the constitution of a state or laws that's opposite or to the contrary of the supreme law of the land is void. So the Fifth Circuit ruled, made a decision that in order to terminate the parental rights, no, I'm sorry, my neighbor, I don't like, I just don't feel comfortable out here talking like this. I don't want to think I'm talking to myself, because that, it's a problem. Could become a problem. He's talking to himself. No, I'm not. I'm making a video live. Now, the Fifth Circuit rule, authored by a judge, he's writing for the majority. This, I think his name is Dennis something. Now, he was appointed by former President Bill Clinton, William Jefferson Bill Clinton, that he ruled that I'm still watching my neighbor. That's why I'm getting, they're gonna, but let me just forget them. Now, the court ruled that you cannot remove a child from the child's parents or home or both because of the mere possibility of danger to the child, stating that that is not enough. Because of the mere possibility of danger, that is not enough. When they made that ruling, when the court announced that ruling, citing with approval another court of appeals, how they have ruled in a due process context, that's the law of the land. That's what they do. They don't sit as courts of appeals of the state. They sit as a federal court of appeals, and they declare the laws that involve a federal question or issues that involve the United States Constitution. Now, let me just go to the back, and I won't be too much more distracted in what I'm doing here. So now, again, the affidavit of removal states that, this is the good part, make sure we're on point. The affidavit of removal that was filed at the same time that the petition to terminate our parental rights was filed states that my child was not removed because he had been threatened with imminent danger to his physical health or safety. That's not why he was removed. According to this affidavit of removal, my child was merely removed because of, quote, the concerns that, unquote. The affidavit of removal authored by Paul Gonzalez states that my child was removed because his supervisor, who was in another location somewhere at home, who he had to get on the phone and on May 6th, Saturday of 2017, CPS came to my house under false pretense. The person that came to my house name was Paul Gonzalez, Hispanic man, who happened to be a Donald Trump supporter like I am. And he had 2 law enforcement officers with him employed by the City of Houston Police Department. And he said, "Hi, my name is Paul Gonzalez. I just stopped by to see how your baby was doing around 10 o'clock at night." That sounded strange to me. So since I saw 2 officers who purported to be Houston police officers wearing a uniform and I saw a patrol car, then that was some kind of proof that they may be who they claim to be. But I asked them, go ahead and still introduce yourself. State your name, please, to this doorbell. There's a camera in there and it's recording you and hearing what you're saying visually and audio. So, hi, my name is Paul Gonzalez. I'm with Child Protective Service. My name is whatever it was. And I'm with the Houston Police Department. Oh, okay, fine. Come on in. They came into my residence where I live, and they asked Paul Gonzalez, he questioned me about baby food, asked me if my child had a bed. I showed him 2 cribs. I showed him baby food. He looked around. He found the house was clean. Now today, my house is not like it was then because of what I'm going through. I'm going through something, people. I'm going through something. I have not had a night's sleep since they took my child. I am dying. I'm suffering. I'm dying. I'm not going to lie with you. That's why I'm finna. So if I'm going to die, I'm not going to just keep. Oh, no. I'm not going to die like this here. So moving on. Well, Mr. Whitfield, actually, that's not why I'm here to see how your baby's doing. We received CPS anonymous information stating that you were at a hospital today and that you were in there acting a damn fool. You were slang. They said, according to this referral that we received, you were in there swinging your baby from side to side, yelling and screaming, acting a damn fool, saying that you knew the president of the United States and that you were a lawyer and that they were unlawfully holding your wife. And I told him, wait a minute now, that's not true. That is not true. In fact, I recorded what took place. That's not true. So let me show you what happened. So that's not true. I got my phone and I went to the recording and I hadn't put it on YouTube because I didn't even know, because my son and I was finna walk out the door and go to the Houston Police Department, file criminal charges against what happened earlier today at that hospital. That's what we were finna do. Because I just got off the phone with a Houston police officer in dispatch. And she told me to go to Macau Road and make a complaint against what happened. So before we could do so, that's when I got the knock, just when I was getting ready to head out the door. So I showed him 2 videos on my phone. And when he saw that, he was somewhat like, wow, this is sad. This is sad. Let me call my Mr. Whitfield. Look. Okay, look. I get it. So I'm gonna go ahead and close this case out because there's no child abuse here. And there's cameras in recording the conversation because I got cameras also on the wall in the house. And these cameras and outside. Some of the video I got, but others is missing, and I don't know why. I don't know why that is missing. And I also recorded from my cell phone. And I put a lot of it on YouTube. Some of it I have not. Now, he called his supervisor. Her name is Tanya. According to the court reporter, it's spelled Tanya. I thought she said Tanya, Tanya. And according to her, she wanted to remove my child. And I kept asking her to give me a reason. After about 4 hours, Paul Gonzalez approximately spent 4 hours after he ended his investigation after an hour. After an hour. And the police, after they got to know me, the police, they got relaxed, started having a conversation because they said there was no child abuse. They all agreed that it was a false report. So they stood out after they exited my house. They exited the first entry was authorized with consent. The second entry was a crime. And this is what they're trying to avoid getting around. But this is necessary to show you that my child was not removed from it. So this is you have to understand the authority that CPS has in order to act. So in this way, he calls Tanya Johnson. Hey, there's no child abuse here. I got this refer. I've been out investigating. I got 2 law enforcement officers with me, and we received a false report of child abuse stating that the father was at the hospital yelling and screaming at staff boys, claiming that he was a lawyer and he had to be escorted off the hospital, him and the baby, because of his behavior. Father had recorded what actually occurred, and I'm looking at the videos, and that was a false report. None of that is true. None of that is true. I've seen the videos. But as nature would have it, or say, this is not what she wants to hear. This is not what she wants to hear. This is not what she wants to hear, that there was no child abuse. She wants to hear that there was child abuse. That there was child abuse. And this man has interviewed me. We out here laughing and joking about how I came under this, because he asked me questions. How do I support myself? I tell him I receive a crazy check. Just like that, man, I receive a crazy check. And I explain how people from Mexico has come over here taking our jobs. And so I had jobs and I prefer to work. And President Trump said he's going to get these people sent back to Mexico and build a wall. And he's all, okay, I get it. And the police, they all sitting up and listening, okay. You know, and so I don't recall telling these people at the hospital I knew President Trump and that I was a jailhouse lawyer. But I went and told him, hey man, I don't know where that come from, but I did serve time in prison, and that